Lord, we ask that you bless us in the presentation that we are about to hear. Grant that it assist us in furthering our efforts to defend and protect your creation and to defend all that is good and in accord with your plan for creation. Grant also in particular that it assist us in understanding your law and incorporating it into our law to protect unborn children. Grant also that it further kindle in our hearts the love that animates our pro-life efforts and inspire us to increase those efforts. We ask all of this through the name of your Son, Jesus. Amen. We're very honored to have a really, really outstanding speaker for this presentation. Father Robert Spitzer. He's a Jesuit priest who served as the president of Gonzaga University. He's retired from that role now. He's a philosopher, an educator, an author, a speaker, and just a really, really erudite speaker. He has founded 7 national institutes, 2 of which are particularly of pro-life concern. One is called Healing the Culture, which is dedicated to developing educational materials on the philosophical underpinnings of the life issues. And then the other of the institutes that's of particular pro-life concern is University Faculty for Life, which it promotes pro-life teaching among university professors, obviously very sorely needed. Of his 13 books, the 2 that are particularly relevant to pro-life concern is one called Healing the Culture, and the other is called 10 Universal Principles. Father Spitzer's presentation today is on the topic of personhood and the inalienable rights of preborn children. So that's my introduction of Father, and at this point, I'll turn it over to him. Father?
Thank you so much, everyone. It's a real honor to be with all of you who are working in the pro-life movement. And I just wanted to start off by talking about a little bit about, well, why talk about personhood? Why talk about inalienable rights? And the simple answer is because it not only lies at the heart of the pro-life issue, but it's almost like the middle term that the secular culture has to listen to. I mean, obviously, we can talk sort of a religious approach to things, and we can be ignored. We can talk sometimes about something that is specifically, focused on a particular political, party or political doctrine, and they can still ignore us. But you really can't ignore the topics of personhood and inalienable rights in a culture like our own. It kind of forces the debate. So my objective in talking today is to give a language that will convince people, especially young people, who may be just sort of out there on the border. They just don't know, well, do they believe in this? Do they not believe in pro-life? Maybe they're on the edge, or maybe they're convinced pro-choice, pro-abortion people. But we can convince them to turn that around by making a really suitable case on the basis of personhood and on the basis of inalienable rights of individuals. So that's my objective today, and I'm going to start with personhood. I think we live in a time when the biological case for personhood is very, very solid. Now, the one thing I'm going to assume, I'm going to start talking about human life here rather than personhood. I'm going to get to personhood a little bit more deeply in a moment. But right now, what can we tell biologically about a preborn human being? And all of my examples are going to pertain to a single-celled zygote. So at the moment of fertilization, there is a very special cell that is formed. It's unlike any other cell in the human body. Many of you who are doing pro-life work are already familiar with this, but like a skin cell, it's going to pertain to skin alone. A heart cell will pertain to the heart alone, etc. But a zygote is a very special, it's a totally unique cell because it will give rise to every single cell, skin cells, heart cells, brain cells. It's going to give rise to every single cell, and the sequencing of every single cell of the human body, of a human body throughout the entire course of its existence. So we can say, from the very beginning, that this zygote is a cell, a unique cell that is in potentia. That is to say, it is right, it's a pre-existence, as it were, of every single cell that will occur in a particular person throughout the course of his or her lifetime. So that's the first thing. That's really important to note. Every cell is contained in that zygote. As it unfolds, it will be unfolding from the zygote itself. That's going to be the origin of every single cell throughout the course of that human being's existence. That's the first thing that's present, is this unique kind of cell, the zygote, at conception, at fertilization/conception. The second thing that's important to note is that at the very same stage, single-celled human zygote, there is a complete, unique, specifically human genome. So it's specifically human. That means it couldn't be anything else other than human. And it is a unique human. So there never was any human like that human, nor will there be any other human like that human in the history of humankind. So that's all present. Indeed, if you could sequence the entire genome that's there, you would have a very good idea, not only of what that human being would look like as an adult, you'd have a very good idea of most of the capacities, or at least the embodied capacities that human being would have. Of course, you wouldn't have anything, that would determine that person's beliefs, that person's choices, and certainly not the transcendent mystery that we'll be talking about in a moment. Now, this is kind of an undeniable fact. That the human being, not only that the human zygote, that single-celled stage, not only has the complete human genome, a unique human genome, it also is in potentia every single cell that will occur in a particular human being over the course of his or her lifetime. So what is that human being? Well, what is that cell? It's a human being. That's exactly what it is. And that's why every single, well, not every single, but the vast majority of embryological textbooks explicitly say that a new, unique human being occurs at fertilization. At the time when the sperm, the egg meet, and of course, prior to the fissioning process, whether that zygote is attached, whether it's not attached, is irrelevant. The point is that already every cell, every unique cell that will occur in that human being over the course of that lifetime is present in potentia in that cell. It's got to be a human being. It can be nothing other than a human being. It certainly is alive. It certainly will proceed to adulthood if you don't interfere with the process. Now, of course, there are a lot of people who try to say that is not the point at which a human being can be identified. A human being only occurs after that zygote has developed for quite some time. But of course, this is simply an arbitrary criterion. Everything that zygote will develop into is already present. So why, at the single-celled stage, Why in the world wouldn't we call that a human being, since everything is already present? All the cells in potentia are already present. The full, unique human, specifically human genome is already present. Why would you say that you'd have to have 21 weeks of development? Why would you have to say, well, it has to be outside of the womb? It has to be a human being, extra utero human being. Why would you have to say that, no, it's when the frontal cortex gets developed at 24, at the age of 24? What, this is ridiculous. All of these things, all of these matters of unfolding, they don't, all they have that the zygote doesn't have is the development of what's already there in potentia in the zygote. So to basically, in the Aristotelian language, the stage of development is merely an accident. The actual substance, that is to say, the tati ein enai in Greek, the what it was meant to be, is already present in the zygote. The unique human being is already present in the zygote, whether it is developed or not. And so, of course, we see, and by the way, I'm going to be comparing things to slavery throughout the entire presentation here. And the reason is because in our country, as you know, slavery was approved unanimously by the Supreme Court in Dred Scott versus Sanford 140 years ago. And with these remarkable words that we'll be discussing as we go along, but that since it is said that these human beings do not have any specific rights guaranteed under the Constitution, therefore, the Negro people, the persons whose status is under question, must subject themselves and be subject to the superior race. Now you say, you really, a unanimous constitutional precedent, it basically enslaved these people and called white people superior and black people inferior? That's exactly what I'm saying. This happened. But what was the criterion, that was used? If you look at the Supreme Court decision, or if you go back and you look at Bartolomé de las Casas in the New World, when he was, of course, trying to defend the cause of the Indian people against the Spanish conquistadores, who basically wanted to enslave the Indians. He went to Valladolid and argued against Sepulveda. And Sepulveda's argument follows the same course as our Dred Scott decision. It basically goes like this, that even though the Indian people, or in the case of Dred Scott, the people of African ancestry, even though those people look like human beings, they certainly are capable, very intelligent human beings. They are basically appropriating education and culture faster than the Europeans, and they're basically mastering mathematics, they're mastering linguistic skills, they're mastering architecture, they're mastering music as fast as any European ever did. It's pretty clear that these are human beings. But the argument was made by Dred Scott and by Sepulveda. No, they're not full human beings. They're not fully developed. They haven't reached the high state of culture just yet. They don't have the same kind of musical instrumentation. They still haven't mastered the nuances of architecture. And of course, in this Bartolomé de las Casas, in the case of the Indians, and of course the plaintiff, Dred Scott, and so forth, were screaming out, well, it really doesn't matter what stage we have reached. The point is, we are going to get there in a very short time because we have all of the potential, like a human zygote, all of the potential intellectually, musically, aesthetically, right? All the potential morally in terms of empathy and love, and certainly spiritually in terms of the awareness of transcendence and God. We've got all the potential to reach the highest stages of development. That's not even in question. The only question is, do you have it now? And of course, we know what poor Las Casas law, he didn't lose the debate, he won the debate. He absolutely trumped Sepulveda. He just basically said, you have based your entire argument on a historical accident that will be negated within a very short time. I have based my argument on the substance of the humanity of these Indian peoples whose lives are being extinguished by these bloodthirsty conquistadores. And of course, the idea, for Las Casas was, hey, I've got this thing. I've got the substance identified. They're human beings, and I can surely show that they are human beings. Well, their state of development, that's merely an accident. It will soon change, but their substance will not. And that is the case too, in the case of the pro-life movement. The substance is already there. Yes, their development will change. In fact, their development will continue to the age of 24 when the frontal cortex is finally developed, et cetera, when their muscular frames are developed fully, et cetera. All of these things may happen over the course of time, but that's just an accident. They will reach the full stage of development. The point is, it's all there from the beginning. It's all invested in the substance, and the substance is the human zygote with its unique human genome. That is unquestionable, and that's why most embryological textbooks say the new unique human being comes into existence at fertilization, no qualifications are given to that subject. So we don't want to then make the mistake, the classical mistake, which justified slavery for centuries, that development should be confused with the substance of a human being. And the same thing is occurring today, very conveniently, for the pro-abortion movement. They're trying to say that stage of development is relevant, whether or not the substance of the human being is complete at the stage of the single-celled human zygote at fertilization. We just have to simply say no. We simply have to resist this. We have to say the case can easily be made on the basis of biology that this occurs. Now, of course, I would maintain as a Catholic, and you can't use what I'm going to talk about now within the context of a secular argument, but there is very good evidence that this human zygote also has a soul. And I won't belabor the point, but these near-death experiences are quite remarkable in terms of showing the existence of a transphysical soul that will survive bodily death. I mean, after all, when 81% of blind people see for the very first time when they're clinically dead, when they've had a heart attack, flat EEG, fixed and dilated pupils, no gag reflex, mere sputterings of neurons in the lower brain, but nothing, no electrical activity in the cerebral or frontal cortices. I mean, if you look at that, you just simply say, yeah, and this person suddenly, for the first time, when they don't have a single visual apperception or image in their physical brains, they're suddenly reporting accurate veridical data. They're going outside the hospital walls and describing trains that are passing by, going outside the hospital walls and identifying a tennis shoe that's sitting there on a third floor ledge. When they're going above the car, and the blind lady is identifying every single person who's around the car after the accident has taken place, and she's blind from birth. Are you kidding me? The evidence is almost overwhelming that we do have a transphysical soul that will survive bodily death. And that's now being confirmed by studies of terminal lucidity. So this is, a pretty clear. But what's really interesting, I'm not going to get into Sir John Eccles' arguments right now because it's going to take a little more time than I have. But Sir John Eccles also has some very, very good arguments in a book called The Evolution of the Brain and the Creation of the Soul. And it's a very fine book, which people should take a look at. By the way, Sir John Eccles is no dummy. He's the Nobel Prize winning physiologist who just also happened to have a PhD in philosophy. And he's written this very fine book, which does give a very good intellectual argument for a soul. There's also a very fine book written by David Chalmers, who is at Oxford University, talking about the hard problem of consciousness and why it is that self-consciousness cannot be reduced to a set of physical processes. But these are beyond the scope of my investigation. The first thing that I want to say is there seems to be evidence that we have a soul, and that soul, actually, that transphysical soul that will survive bodily death, we have now quite a few incidents that have been, detailed by the University of Virginia Medical School Department of Perceptual Studies. But essentially, what they show is that people who die, they go to heaven. They oftentimes see deceased relatives and friends before they come back into their body. Let's say they're resuscitated, they come back into their body. But some of the people that have been identified, for example, in the case of, some of you may have seen that movie, Heaven is for Real. There is this little 4-year-old Colton Burpo who essentially says that he saw his sister. Well, his sister died and was miscarried at 2 months old. She was only 2 months in her mother's womb, and she was miscarried. Well, he gets up to the outskirts of heaven, and he's this little 4-year-old, and this girl comes right up to him and just throws her arms around him and hugs him. And he goes, "Well, who are you?" And she goes, "I'm your sister." And he goes, "You're my sister?" "Well, no, my sister's somewhere else, but you're not her." And she goes, "Oh, yes, I'm your sister." And she describes the whole, scene of course, mommy, lost me when I was just 2 months old, but here I am now. And he says, "Well, what's your name?" And she goes, "Well, I don't have a name because mom and dad didn't know whether I was a boy or a girl, so they didn't give me a name." So of course, Colton, is resuscitated. He comes back, and of course he's relating this to his mother, and he says, "Well, I met my sister." She goes, "Of course you know your sister. Your sister's right here. You're not that sister. I met the other sister who was in heaven." And she goes, "Well, what are you talking about? There's no sister in heaven." She goes, "Oh, yes, there was. You lost a little baby when I was before I was born." And she goes, "Oh, who told you that?" "She did." And he goes, well, what was her name?" And he goes, "I asked her the same question, but she said that you and Daddy didn't have a name for her because you didn't know whether she was a boy or girl." Well, the point, of course, I'm getting to here is that the mother, of course, is jaw dropped. The father is jaw dropped because they never disclosed anything like that to Colton. But my point is, there is certainly a possibility that we not only have a biological case for a complete human being, but perhaps even an interestingly, empirically verifiable case for the existence of preborn human beings, the existence of a soul in preborn human beings. I'll leave it simply at that. And of course, we can't use an argument from the soul quite yet. But notice that the evidence for the soul that I'm using here is subject to scientific scrutiny. And there are some really excellent scientific studies that have been done by and published in peer-reviewed medical journals, especially the one that is done by Samuel Parnia in 2014 with 2,060 subjects. And of course, the one that's done by Pim van Lommel in the Lancet, which is which is England's #1 medical journal, published there from 2001, among a variety of other good medical studies of these near-death experiences. We're getting to the point where you might be able to, at some point, ascertain in some kind of highly probabilistic way the existence of a soul, not only in adults, not only in 6-month-old human beings, but also in preborn human beings who have been witnessed by others who have, quote, gone to the other side. Anyway, I just leave that for you. But yeah, do we have evidence of a human being, within the womb? We absolutely have evidence of a human being within the womb. And I think there's plenty of it. But I'm just going to proceed to the whole area now of personhood, because this is where we have been sort of boondoggled in the pro-life movement. I think we have an excellent biological case, and frankly, I think we have empirically verifiable evidence even of a transphysical soul that at least is highly probabilistic enough to get people thinking. But what's the problem? The problem is that the Supreme Court, both in Dred Scott and that's the decision that justified slavery, and also in Roe versus Wade, the Supreme Court has made a fallacious distinction between human being and person. For literally centuries, nobody distinguished a human being was a human person and a human person was a human being, until they got to the point where slavery needed to be justified, where certain human beings need to be counted as chattel, that is to say, as property, which is why it's called chattel slavery, right? The whole point is the reclassification of certain human beings as non-persons enables them to be called property. And of course, property can be disposed of. Property can be destroyed. Property can be disposed of in any way according to the whims of the property owner. Now the case in point, of course, in England, there are a series of cases that where we have in the 1700s reclassifications. We have reclassifications of human beings as non-persons or property that probably go back to the 1500s. And of course, these are used to justify slavery. In other words, these are not, these human beings are not really persons. In other words, legal persons deserving of rights, right? A certain kind of person that's deserving of rights, the certain kind of human being that's deserving of rights, that now becomes the new definition of person in order to justify slavery. So of course, once you do, and of course we have the Virginia statutes that go back to the 1650s and the 1700s, where we can clearly see that people of African ancestry have been redefined as chattel, as property. And so they are considered ripe for slavery, that people can own them and dispose of them as they please. So now that, of course, has been reversed, not only in a series of amendments to our Constitution, which gives us, of course, hope for Roe v. Wade, but also in every Supreme Court precedent, this has been reversed. But we see the same logic in Roe versus Wade, that these human beings, this single-celled zygote, right? We see that the logic there is very cunningly put together. How is it put together? First, the person who wrote this decision for the justices basically throws into question the fact that the single-celled zygote, that preborn human beings are truly human life. So that he wants to cover his tracks. So he says, hey, we don't know when human life begins. Of course we know when human life begins. Every embryology textbook at the time said that human life begins, the new unique human life begins at fertilization, because of course, there was a strong hint that the complete human genome was there, although we didn't have the capacity to fully sequence it at that time, but we certainly knew that and had that capacity about 8 years later. But the point is it was thrown into question because we don't have absolute proof, that the complete human genome is there, because we're not sure about the status of a human zygote, which we really were. We always knew that the human zygote was in potentia, every single cell that would be produced in a single person throughout the course of his or her lifetime. We certainly knew that of the human zygote at the time. But anyway, a case was made that, we're not sure of when life begins. And if biological experts and theological experts can't tell us when human life begins, who are we, the Supreme Court, not a series of, who are we to determine that human life exists? Now, that's very crafty, very interestingly done. But the problem, of course, in doing something like this is you're creating the burden of proof on the person who is the victim. In other words, a person has to prove that they really are a human life in order to be protected when there is doubt. That this is absurd. In other words, we're saying, and what the Roe v. Wade decision says, I mean, it's literally writ large right there, is if you are in doubt about whether a person exists, you can actually say that the person doesn't exist. You don't have to give the benefit of the doubt to the potential human being until there's positive proof that he is a human being. Of course, we don't do this in any other area of law. We don't do it in any other area of humane studies. I mean, of course, the presumption must fall to life. You can't sit there and say, go ahead, we'll sanction death if we're not certain. So the hunter who goes down, he's hunting with his buddy, he loses track of him, he hears the rustling in the bushes. I'm not sure whether that's my friend or a deer. I presume, because I'm not sure, let me presume that it is a deer. He shoots the guy, and there is his friend has fallen dead. But what the court would then say, or would it really then say, you're exonerated. When you were in doubt, you went ahead and shot your friend. Well, we'll exonerate you. You didn't have to give the burden of proof, the benefit of the doubt to protecting life. You only had to give the benefit of the doubt to protecting a certainly existing life. And of course, this is absurd. Nobody would do this. It won't happen in any other area of law. But yes, we've done it in this Supreme Court decision. And once that's off the ground, right? Once, people say, well, there's a possibility maybe that the full human genome was not there, we can go ahead and doubt that and sanction the killing of that life. Since that time, 7 years later, we now have complete scientific evidence that there is a full human genome. We now have a complete scientific evidence that that single-celled human zygote is in potentia, every single cell in that human body. And that zygote, by the way, is a self-directing, self-actualizing unit, a biological unit that is literally producing all of those cells over the course of a lifetime. It is the unity of that human being, of that human body over the course of a lifetime. We know this. We know it conclusively 7 years later. But the justices, after having used this faulty logic, after having given the benefit of the doubt to certain human life, instead of giving the benefit of the doubt to the possibility, the potential, the high probability of human life, the justices let their decisions stand. And that too must be reversed. So again, there's real flaws in the identification of personhood. But it gets even worse, because in both the Dred Scott decision justifying slavery, as well as the Roe versus Wade decision, what we see is that when there's a doubt about personhood, right, no credit is given to the inalienable rights of that potential person. And this is a really major legal error, both in Dred Scott and in the Roe versus Wade decision. What's the problem? Let me just start off by, I know this sounds a little bit technical, but it's important to see inalienable rights belong to a person by their very nature. That's what it means to be inalienable. I was born as a human being. I have inalienable rights in virtue of the fact that I am a human being. Simple as that. You cannot compromise that. It actually belongs to you by your very nature. It's a right in our Declaration of Independence. Listen to these words. We hold these truths to be self-evident, that all people are created equal and are endowed by their creator, not by any human being, not by declaration of any constitution, not by declaration of any positive law or statute or Supreme Court decision, but by their creator with the inalienable rights of life, liberty, and the pursuit of happiness. They can't be alienated from you by any declaration of anybody. You have them. In fact, it belongs to you and yourself. And that's how, by the way, these inalienable rights that belong to us by our very human existence, it's the violation of those inalienable rights that enabled the Constitutional Convention to break with Britain. It couldn't have broken with Britain if it needed a legal precedent, because we operated as colonies under British law at the time. But it was the violation of the inalienable rights that allows for the break with the British government, with British statute. And for that reason, they used that inalienable rights doctrine to get our country off the ground. Now today, I mean, this is still writ large in our common law, right? Inalienable rights are never to be found in any constitution. Why is it that we don't see any mention of inalienable rights in the Constitution of the United States, except in the 14th Amendment, which basically says that no state shall violate the inalienable rights of life, liberty, and property? And by the way, what's the origin of the 14th Amendment itself? Slavery. That's right. In other words, there were certain states, Confederate states, that had the nerve to basically declare null and void the inalienable rights of life and liberty of African Americans. Yeah. So what's the origin of the 14th Amendment? Never any more shall we have any states that will say that a human being does not have the inalienable rights of life, liberty, and the pursuit of happiness. That's the only mention. The Bill of Rights doesn't say every human being has the right to life. The Bill of Rights doesn't say every human being has the right to freedom, to liberty, etc. Why? Why doesn't it say that? Because our founding fathers were too smart to do something dumb like that. They knew that if they declared inalienable rights in the Constitution, that would subject the inalienable rights to what? To the purview of the state. If the state declares the right into existence by matter of the constitutional fiat, then states can undeclare those rights. If the state says, oh, you have the right to the freedom of press, it can undeclare it during the time of martial law, et cetera, et cetera. An extrinsic right, a state declared right, can be undeclared, can be negated temporarily or permanently by a state. But an inalienable right can never be undeclared by a state body, can never be undeclared by a constitution, can never be undeclared by any Supreme Court precedent, because those rights belong to people by their very nature. They were never within the state's jurisdiction to begin with. So the point at hand then is, we got a problem, ladies and gentlemen. We not only have this very spurious notion that you can separate personhood from human beings, certain human beings deserving of protection under the law, but other human beings not, that drove both slavery and drove also the Roe v. Wade decision. Not only do we have this spurious little problem, we not only have the problem of not giving the benefit of the doubt to the potentiality of human life when we are uncertain, but giving the benefit of the doubt to the sanctioning of death when we're uncertain about whether life begins. This, of course, is two really tragic mistakes in both Dred Scott and Roe v. Wade. But now we have a third little problem here: the mix-up of inalienable rights and extrinsic state declared rights. Because once Dred Scott, let's start with Dred Scott. So Dred Scott says, look, these Black Americans, boy, they came here under enslavement. I mean, the white race was dominating them from the very beginning when they came here. So, I mean, they were inferior from the very beginning. So we're really uncertain about whether they have the right to freedom. So what do they say? Well, since we're uncertain about the right to freedom, let's sanction slavery because of our uncertainty. So that's what Roe v. Wade does with respect to life. We're uncertain about when life begins. Let's sanction death for those potential human beings. And of course, 7 years later, we know for sure that they are definitely unique, specifically human beings. And of course, have a high likelihood of a transphysical soul. The point, though, that I make here is now we get the Supreme Court, and Dred Scott says, okay, since we're uncertain about their humanity, how are we going to find out whether these Black human beings, whether they really have inalienable rights or not? We'll look to the Supreme Court, we'll look to the Constitution of the United States and any Supreme Court precedent that says that they're human beings. And they say, whoa, hey, look, there's no Supreme Court precedent that says that they're human beings. Well, therefore, we declare that they're not human beings deserving of the right to freedom. There's no specific guarantee of the freedom of Black people in the Constitution or any Supreme Court precedent. Therefore, they don't have any specific rights to freedom. Notice the errors that are performed when this happens. The first error, of course, is they're treating the inalienable right to freedom and the inalienable right to life, in the case of the Roe v. Wade decision, they're actually acting as if these are not inalienable, that they're within the jurisdiction of the state to declare or undeclare. That's the first huge mistake. Freedom is not up for grabs. Life is not up for grabs. You don't have the right to enslave anybody. You don't have the right to kill anybody. The whole point is that they're inalienable rights. They belong to people by their very nature. We hold these truths to be self-evident, and we don't need any state to declare them at all, because it's so obvious, it's self-evident that, of course, they have these rights by their very nature. That's how the that's how the Founding Fathers set this up. Now, of course, we go to the second, yet another major error that the court makes. Forgetting completely about inalienable rights and having a question about their personhood, they search for a constitutional precedent or for in the Constitution itself, and see that there's no specific declaration of the right to freedom for African Americans. What do? They say that the silence of the Constitution and the silence of Supreme Court precedents indicates that they don't have the right to freedom. Do you see the mistake? I mean, it's unbelievable. I mean, this is like elementary error in case evidence 101. Silence doesn't mean anything. Silence is silence and cannot be construed to mean yes or no. Yes is yes. No is no, and silence is neither. The idea then of interpreting the silence of the Constitution and Supreme Court precedent to indicate the absence of rights of African Americans is so patently absurd from a logical and case evidence point of view, and at the same time, it is patently absurd from the vantage point of humane conduct itself. And so the mistakes are prolific. Did Roe v. Wade do the exact same thing as Dred Scott? Absolutely it did. First of all, Roe v. Wade completely ignores the inalienable rights of that potential human being. But of course, we can go beyond 1973. We can just basically say a few years later, we know for certain that there is a real human being there in that human zygote with a full, unique, specifically human genome. We know that that's the case. And yet, of course, that decision was not reversed on the basis of a lack of evidence. But the point is, what does the Supreme Court do? It searches—
Father, 12 minutes to go.
Okay, searches the Constitution to see whether or not specific rights are guaranteed to the fetus, and hearing the silence of the court, interprets the silence to mean that you can sanction the death of these human beings because there's no specific precedent or anything in the Constitution guaranteeing that they actually do have life. There's, as I said, the absurdities are, simply beyond belief. This is a terrible decision, and it needs to be reversed in every imaginable way. And so my point that I want to say here is, we can help to do this. And what we can do is I'll just give you the number one. We must insist on the basis of biological evidence alone that the human zygote is a full, specifically unique human being. Number two, we must insist that all human beings are persons. There are no human beings that ever existed that did not deserve to be protected under the law versus those that don't deserve to be protected under the law. This is it's an absurd statement. It's inhumane. And of course, it was never intended by the constitutional fathers. Number three, we have to insist that the right to life, as with the right to freedom in Dred Scott, is an inalienable right. The Supreme Court can't touch an inalienable right any more than the British government could contest the inalienable rights of the colonists. That was the whole genius of it. That was the discovery. By the way, the whole discovery of inalienable rights came from the Salamanca school and from a great philosopher, Francisco Suarez, a Jesuit philosopher who was a priest, by the way. And of course, his work was read by Hugo Grotius, the father of international law, who in turn passed it on to John Locke, who in turn passed it on to Thomas Jefferson. My point, though, is inalienable rights are real. Inalienable rights are self-evident. Inalienable rights belong to everybody by their very nature, and no Supreme Court, no governmental body, no state has the right to toy around with them, declare them, or undeclare them. They belong to you by your very nature. We must insist on this. The idea of transitioning, as they did in Dred Scott to justify slavery, inalienable rights to extrinsically declared rights under control of state is outrage. It's an outrage. And the fourth thing is, yes, I do have a little passion about this subject. I must say, the idea of interpreting the silence of the Constitution and Supreme Court precedent to indicate that people do not have the inalienable rights of freedom, liberty, and the inalienable rights to life. This is, again, an absurdity of the greatest order. We reversed the Dred Scott decision because we saw the horror of slavery and what it did. Yes, it took a civil war to do it. And I hope we don't have to have anything like that in the future. But the main thing that we must insist on is we have to get back to this just humane and logical and responsibly evidential viewpoint that human beings are human beings, no matter what their stage of development. Human beings have inalienable rights that cannot be extinguished by the state, and the absence of any constitutional mention or any Supreme Court precedent certainly does not justify the sanctioning of the death or the slavery of patently evident human beings. So thank you very much for your kind attention. I just wanted to point this out and just say we have to be passionate and logical about doing this in the public square, because if we do, I think we can finally, I've seen students just turn on a dime, high school and college students turn on a dime when they begin to realize the fallacies, the inhumane fallacies upon all of which both Dred Scott and Roe v. Wade were based. Thanks so much.
Thank you very much, Father. That was, I'm an attorney myself, and so I particularly was impressed. It occurred to me we need to arrange a debate between you and Lawrence Tribe on the right to life issue. Does anyone have any questions for Father? I do, but I'm going to reserve mine. I have a lawyerly type comment / question, but before I go, I'd invite anyone else who has a question to get unmuted and pose your question to Father Spitzer. Jacob, can you keep an eye on the mutes and unmute anyone who needs to be unmuted? And while we wait for others, I'll go ahead and pose mine.
Actually, it looks like Sister Lynn has a question.
Okay, go.
Thank you, Father, for your time and sharing your knowledge and passion. I'm a first-year novice with Sisters of Social Service. I've been very impressed with Sister Paula's ministry. And I'm a physician by my profession. And so my context in surgical critical care is a question related, but not exactly on your topic. If you wouldn't mind to advise or speak to my question, I appreciate. One of the events that happens frequently in surgical critical care is withholding of life support measures that are considered artificial when there seems to be no reasonable likelihood of meaningful life or meaningful recovery. Seems to come up quite frequently. And of course, in the context of my profession, there's an ethics committee that then opines on the issue. But in the case of an unborn, would they be, since they have inalienable human rights, would this issue of withholding extraordinary means to sustain its life then become applicable? I hope that my question is well phrased, and I apologize for any ambiguity.
Well, as I am understanding your question, I think what you're asking is, can a person, let's say a doctor, withhold extraordinary means, as I think you put it, in the case of let's say a preborn human being who is in danger of dying. So, for example, could you withhold maybe NICU? Are you considering that extraordinary means for the fetus or for the embryo there? In my view, the NICU is probably not really extraordinary means. I think basically if the preborn human being could survive with NICU treatment, even though it's obviously very expensive and very extraordinary in many different ways, it is a life-saving procedure that can work a good amount of the time. I think my basic principle is, if you're making a judgment call and you're just not sure whether a life-saving treatment could work or not work, and there is a possibility, for example, of an unborn human being of having meaningful life, you have to make the judgment in favor of giving the life-saving treatment. If there is, if there is doubt, always give the burden of proof to saving the life if there is the possibility of meaningful life. Now, if there, if you don't want to, if there's imminent death that's on the horizon, some doctors may say, well, even if you do give this very expensive treatment to this little child, they will not live more than a few days. Then you'd probably have to turn it over to the ethics committee at some point to make that decision, because the idea of using huge amounts of resources to give a few days of life may be questionable, and maybe it even won't give any days of life. But these are really tough questions. I basically say, look, if you've got a reasonable possibility of meaningful life and the treatment may or may not work, always give the benefit of the doubt to protecting and saving the life. That would be my view. And certainly if it's a NICU procedure, you'd spend a lot of money, but if there is a good amount of possibility that child, I mean, you don't even have to have a good amount. If there's just a possibility that child could, snap to and have a meaningful life, I think that is to say a meaningful chance of life, I think you just have to do it. So that's my view. Always give the benefit of the doubt to the possibility of life.
Okay, thank you, Father. I have a question here from Nadia Smetana, who I happen to know is a director up in, and Leslie has one, will be next. But Nadia wrote hers out. Nadia is a director of a pregnancy counseling center in North Dakota. Her question is, we often hear that if Roe is overturned, each state could decide about the legality of abortion. And the question is, wouldn't that violate, she means the 14th, she had the 4th Amendment, but I think she means the 14th Amendment. So what's your view on whether the 14th Amendment guarantees the right to life in terms of abortion?
Yeah, I think, that's a very ingenious way of approaching it, because, well, first of all, right now, it is correct to say that if the Roe v. Wade is reversed, that just basically puts the decision back into the hands of the state. Now, I think you are correct, and I have actually written about this a little bit in various bulletins and things. But I do think that the 14th Amendment, I think right now, honestly, the evidence that you have a complete, uniquely human, specifically human, unique genome in this zygote, which is in potentia all the cells of the body throughout the lifetime, and the unity of the body of the self-actualizing entity over the course of a lifetime. I think a very good case can be made that the single-celled zygote is human life, and therefore must, if we kind of take out the specious, spurious kind of distinction between human life and personhood, if we just negate that, I think we could make a very good case that if this can be shown, and you don't have to do it beyond the shadow of a doubt. All you have to show is that the possibility of having a unique new human life that is present, that probability is enough to try and at least bring some cases to the court that an inalienable right exists for the human being, and that inalienable right should be protected under the law, and therefore we could get something within federal jurisdiction, at least try to get a precedent into the Supreme Court to say, yeah, that no state can violate that human being's right to life. And so I think, again, we would have to, this would require a great deal of research and a great deal of effort. I think we do have the brain power out there, no question, to make a very solid case on a biological basis for that unique human life, and a very solid legal case to prohibit the distinction between human life and personhood. If we could do that pretty well, then the inalienable rights of that person would have to be guaranteed under the law. And if that were the case, I do think we could sue under the 14th Amendment to protect the life of every preborn human being. I think there's something to that, and I think it's very ingenious. And as I said, I think this is one of the avenues we could take after the reversal of Roe, but I think it's going to have to be really well thought out to get the right kind of precedent.
Thank you, Father. We have one more question. Leslie, Cal, I'm not sure. Cal Leslie is what my readout says. I don't know if Cal is your name or for your state, but go ahead.
I'm from California. I live in Florida now. My name is Leslie McGiven. I was with Sister Paula Vandegar as a volunteer for life for a whole year. I've had Betty Odell come to the church and give us wonderful things. So that I come from a background of that. And I taught natural family planning to a class. Well, one of your goddaughters, Father Spitzer, was in my NFP class.
Oh, no,
anyway,
oh,
so that being said, I think all this is wonderful and great and so logical and so intelligent and so legal. But sometimes in the real world, it's like we can say, you can have a case for that. But in the real world, there's a person, a doctor, a mother at, I'm going to say it, Santa Teresita, a lovely Catholic hospital where they were pushing euthanasia, in that the doctor puts his head up and down like this and says, she's in a lot of pain, isn't she? We'll just give her a little bit of, morphine. And then she was dead in 4 hours. But of course, someone in my family had to say, okay, do it. I'm just saying, in the real world, these things are so hard. And what I want to ask you, Father, is one question was the name of the book that you had said that somebody had written, and I put a question mark there. And then also Mesa de la Costa, you said a fast. I'm not familiar with that, so if you can do that. But then also, if you can just at the end, just like 2 sentences. I had to be off for just a minute, but if you can clearly, shortly say 2 sentences that maybe can help us think in our minds so we can talk to other people clearly, that because of the personhood, blah, 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 and because of, anyway, if you can sum what you said up in like one little sentence for the personhood, one little sentence for that, and then the name of that, the book that was, I guess it was, anyway, the other is probably more important than actually the book for me, but.
Okay. All right. Well, let me just say one thing. What I was trying to do was give at least an apologetic for evangelizing a culture. And I tried to reduce it to 4 principles. So if you're okay with 4 of them,
Okay.
where I'm going to go. So the number one thing is we have to insist right now that a single-celled zygote is a full, unique, specifically human being. That's the first thing. We can prove that scientifically. That's number one. So the logic in Roe v. Wade has to be negated. It simply is the opposite logic. It says we're not sure, but now we are sure. Everything's changed. So you can't even use a doubt argument. The second thing that's really important is there's no distinction between human life and human personhood. The moment you make a distinction between a human life and a human person is only for one reason. You want to marginalize some group of people. When the Nazis wanted to marginalize Jewish people and Gypsy people, they made a distinction between human life and human personhood. saying that human persons are those that deserve to be protected under the law. Jews and gypsies, they don't deserve to be protected. We did the same thing with chattel slavery, calling human beings property, right? And so the second thing we just have to insist on is every single case of marginalization, ostracization, every single case of genocide has been grounded ever and always in the specious distinction between a human being and a human person. We must insist on the universality of personhood for every human being, black, white, red, green, and every stage of development, we can't be, allowing the specious distinction to continue to undermine our civilization. The third thing that we have to defend, I'll make it just three things, keep it easy. The third thing is we have to make the distinction between inalienable rights and extrinsic rights, like constitutional rights, rights that are declared by the state. And if an inalienable right belongs to people by their very nature. And those three rights are life, liberty, and the pursuit of happiness. And there's a very good reason that they alone are inalienable rights. An inalienable right must belong to somebody by his very nature because they are necessary in order for a person to be human. They're necessary in order for a person to act like a human being. Do you need life to act like a human being? Yes, you do. Therefore, life is an inalienable. Do you need freedom, liberty, custody over your own thoughts and custody over your domicile in order to act like a human being? Or can you be a human being and be enslaved? No. So freedom, of course, has to be an inalienable right. You need it in order to act like a human being. Now, let's take a look at whether abortion can be an inalienable right. Well, do you need to abort people in order to be a human being? Obviously not. You can't then say, gee whiz, Jeannie didn't have an abortion, therefore she really wasn't a full human being. Of course, you don't need an abortion to act like a human being. Can a cell phone be an inalienable right? Well, no, you don't need a cell phone in order to be a human being, or the latest smartphone. Do you need to enslave people in order to be, you get the point. So inalienable rights, those that are necessary for people to be human, those inalienable rights, they belong to us by our very nature. No one has the right, by what's called the principle of non-maleficence, no one has the right to deprive you of your humanity. That humanity belongs to you by your very nature. No state has the right to categorically take it away from you or declare it out of existence. That's the whole rationale for inalienable rights, which this guy, Father Francisco Suarez, made way back in 1512 in his book De Legibus. But the key thing to remember is extrinsic rights, they're declared into existence by a state. They can be negated by a state, say during times of martial law, et cetera, et cetera. Now, the main thing is if we keep that distinction between inalienable rights and extrinsic rights, then Roe versus Wade falls immediately because we clearly have a human being. That human being must be a person under the law because we won't make that false and specious distinction between personhood and human beings. Universally, every human being is a person. And then thirdly, since every person has the inalienable rights to life, liberty, and the pursuit of happiness, you cannot deprive that human being of those rights. So that's, in a nutshell, what the argument is. Roe versus Wade has got to fall. It makes no sense. You have to violate one of those three huge points, which, of course, now can be either, in the case of the first point, scientifically established, and the second 2 points legally and philosophically established since the beginning of philosophy of law. So that's basically it. The book I might have mentioned is maybe it's 10 Universal Principles.
That would be.
Yeah. 10 Universal Principles, a brief philosophy of the life issues. It's all in there. So I have a comparison between Dred Scott and Roe v. Wade all the way along the line. And the person you're thinking of is Bartolomé, like Bartholomew, Bartolomé de las Casas. And he was a Dominican friar, lived in about 1560, and he had been an attorney before he became a Dominican friar, and he went over to the New World and saw what was happening to these poor Indians. And so he was, of course, outraged. I mean, they were not just depriving them of liberty and enslaving them, they were killing them. And so he went, he wrote a book called The Case Against, the bloodthirsty, tactics of the conquistadores against the Indian peoples. And the Spanish court got kind of nervous about this book because it was a natural law argument for, for the inalienable rights, basically, of these Indian peoples. And so Sepulveda tried to make the case that in point of fact, these Indian people, they were not human beings because they were subhuman. They didn't have the same state of development educationally as the Europeans. And it was Las Casas, who basically, this Dominican friar, who said, look, he said, they're human beings. That's the substance. Will they get the education of the Europeans ultimately? Absolutely, they will. And then at the end of the day, he goes on to say, you can't say that any state of development will deprive them of the substance that they already have, the potential they have, the power they have within them to become fully developed human beings. You cannot say that their stage of development negates that. That's saying that you can rule out the substance by means of an accident. He had the better argument. Everybody acknowledges it, but it didn't suit the Spanish court at the time to allow him to win that argument. But of course, history has vindicated him again and again.
Thank you so much. Thank you.
In closing, I offer the following prayer. Lord, we ask that you bless us and the presentation, and we thank you for the presentation that we have just heard. And we thank you for Father Spitzer and the intelligence that you've given to him and the grace that you have given him to see the beauty, to explain the logic that underlies your law. We pray also that his presentation assist us in understanding your law and in incorporating it into our law to protect unborn children. And again, we pray that it kindle in our hearts the love that animates our pro-life efforts and that it inspire us to increase those efforts. We ask this through your Son, Jesus, our Lord. Amen.